Now, these are all financial powers that you're granting. So essentially, they can sell property, they can sell stock, they can handle your retirement assets, handle claims. Essentially, they can stand in your shoes, financially speaking, right? One very powerful portion of this document is the gifting powers, right? We utilize the gifting powers in the context of estate planning and also long-term care planning. So maybe you need to shuffle assets out of a person's name and they don't have the capacity to do so, right? So by having the agent, right, being able to transfer the assets of that principal, say it's their spouse or their parent is the principal, and the agent is the person who's helping them. By the agent transferring the assets to themselves to get the money out of the principal's name so that they can pay less estate tax, or maybe you're in a long-term care situation and maybe mom or dad or the spouse wants to apply for Medicaid, like community Medicaid, or maybe they need more skilled nursing home Medicaid. Now, to move the money out of their names, they have to use this power of attorney. And under the general obligations law, which is the law that controls the power of attorney, that's considered a gift when you transfer funds to yourself without exchanging something of equal value. So having that gifting power is really powerful, and it's a very effective and helpful tool to have when you're doing crisis planning or when you're trying to shuffle assets and avoid estate tax. So that's a really great thing to have. There are other tools that you can employ in the power of attorney. There's something called a monitor. It's essentially somebody who checks up on the agents. We don't use that. Frankly, if you need to have a monitor, it's probably not the right agent to choose. You should probably choose someone else, is my opinion. You can compensate the agent. This is generally also not used in our firm because in the documents we use, because generally the person who's the agent is a family member or a friend and is doing it, and they're not seeking compensation. However, if you do get the situation we've had where there's a professional who's acting because the parties either don't have or don't want to ask somebody who's a family member or a close friend to do it, then in that case that they anticipate that they would be compensated, and we write it in for that reason. Part of the power of attorney law that has changed over the last couple of years is now not only does the principal, meaning the person it's their power of attorney, sign it, but also the agent. So the agent must sign it for it to be effective. And so now it's effective as to the principal when they sign it. It's effective as to the agent when they sign it. And then to use this, the agent must have the power of attorney, the actual document, in their hot little hands, and then bring it into the financial institution and show them, this is the document I have and I want to use it. And, let's go ahead and I want to be able to effectuate and utilize this power of attorney. So possession is very important here.